a webinar on hard Brexit and ways to cope. I'm privileged and honoured to have with me 𝗂𝗹 the CEO of Complyport, who's an expert on regulation and compliance in the UK, who's going to guide us through what awaits us post January 2021 when we fall out of the European Union and what impact it's going to have specifically on financial services in the UK. You know, just some housekeeping rules as well. If all of our guests can keep their microphones switched off during the presentation that Paul's going to give us, and also if you do have questions, please feel free to send them over to us so we can get some response from Paul. In terms of some background on Paul, 𝗂𝗹 is the CEO of Complyport. He's one of the leading experts in the UK on compliance and regulations in financial services. Currently, he's chairman of the Brexit Working Group of the Association of Professional Compliance Consultants and is the member of the Examinations Board for the Institute for Securities and Investments. So Paul's going to give us some expertise and insight into what's likely to happen really from January onwards. Also, if you are part of a financial services firm and you do need some help, or if you want a conversation with experts, Complyport consultants are available to provide that. And also my colleagues at the LGCA are able to provide you with white label platforms for e-learning for companies who want to do some in-house training for their staff. So if you do need any of that, all the contact details are actually on the slides, and we'll be sending follow-up emails as well. So without further ado, 𝗂𝗹, it's your turn now to speak to our guests and give us some insight into what awaits us in January 2021.
Thank you, John. Well, let me begin my comments with a very brief history lesson. You may recall that going way back now into the summer of 2016, we had a referendum. And although at the time, I think most commentators were thinking that the referendum was poised on something of a knife edge, I think most commentators actually thought that the referendum result would probably favour remaining in the European Union, and how wrong they all were. So we ended up whereby we had a decision to leave, and the balance of that period right through to the end of 2019 was really focused around, well, what does Brexit then actually look like? We recall, you know, the heady days, shall we say now, of Theresa May's premiership and the famous quote, "Brexit means Brexit." Unfortunately, it didn't. So what happened was that we ended up in a period of sort of stalemate where the UK government tried to agree a fairly orderly exit programme with the European Union. I think as part of that, there were a couple of landmark documents, the first one setting out the general scope for negotiations and agreement, and a second document actually trying to deal more constructively, perhaps we would phrase it, with the question of the Northern Ireland border, which, surprise, surprise, nobody seemed to have recognised was potentially a pretty significant issue in Brexit negotiations. Nevertheless, we eventually got there, and by the skin of the then new Conservative government's teeth, managed to get to a point where without agreement, but with the prospect of perhaps doing so within the transitional period, the UK left the European Union on the 31st of January this year. That left us with a period of 11 months in which to try and structure during the transitional or interim period some form of codified, orderly, future trading framework. And I use the word trading advisedly because a lot of the focus and a lot of the commentary around Brexit focuses on what we call trade. Now, whilst there can be trade in services is generally done outside of the framework of trade agreements. Under the World Trade Organization rules, for example, there is a very, very shallow and brief mention of services in the round, and most of the focus is actually on something that can be grown, mined, manufactured, or otherwise produced and shipped. So the whole focus of the Brexit trade negotiations is actually on, by and large, those kind of things, goods and manufactures that are imported or exported across frontiers, primarily from the UK into the European Union and vice versa. So you might then say, well, where does that leave services? Well, many services are not cross-border services. They're consumed within the state. So they will largely, but not exclusively, fall outside of the scope of any agreement. And that will leave those services that actually are cross-border services. And many of those are actually, if not already covered by, can be covered by international multilateral agreements. So such things as telecoms protocols or broadcasting rights or similar are the kinds of things that traditionally would have been dealt with by way of international treaty. Where does that leave financial services then? Well, I'm afraid the answer is a little bit in limbo. And that's because financial services was never planned to be within scope of the Brexit agreement that was under negotiation between the EU and the then May government and latterly the Johnson government. Instead, there's a reliance on what was termed equivalence, and I'll come on to equivalence in a second. But in framing my comments here, it's important to understand that it was never intended by the EU or by the UK government that any detailed treaty or agreement would cover financial services as part of the main trade agreement. It was always the intention that financial services would be dealt with separately. And that's quite important because one of the major benefits of the European Union was a development which accelerated from right back in the early 1970s through to reaching its climax, I suppose you would call it, around about 2009, was the evolution of the single financial services market and a system that was known as passporting. And what that meant in simple terms is that a firm could be authorized by its own home state regulator, who could issue a passport for various types of services that were offered into other markets, and the host state regulator would recognize the validity of that passport or that right to do business in another territory and allow that to be done without the need for the firm to be regulated by its host state regulator. Now, those of us old enough to remember back in the days before the investment service, particularly way back in the early 1990s, will recall that back in the bad old days, if you wanted to do business overseas from, say, the UK, you had to apply to the local or host regulator in every state in which you wanted to do business and obtain authorization to do so. And that was a lengthy, expensive, and complicated process because different regulators had different requirements and standards. And one of the benefits of the single financial services market was a streamlining and what we might call a significant degree of standardization in what regulators needed to both provide authorization or to recognize a passport that was issued by an overseas regulator. So to that degree, the key point here that we need to observe is that the single financial services market, as far as the UK is concerned, will come to an end at 2300 GMT on the 31st of December 2020. In other words, on New Year's Eve this year. So we're now only a matter of effectively 5 months away from a situation where the current single financial services market benefits will cease to exist as far as UK firms are concerned, but also as far as overseas firms are concerned that currently passport into the UK. I think the figures may have changed slightly, but there were around 7,500 to 8,000 firms that relied on passport capabilities within the European Union. About 5,000 or so of those firms were, I believe, inward bound passports, and the balance were outbound passports from the UK. So there are a significant number of firms who will now have to think carefully about whether or not they need to apply to one or more regulators in order to be able to continue to do business after the 31st of December, I should correct myself, 2020. In other words, from the 1st of January 2020, whilst that's a bank holiday in most countries, certainly anybody working that day or for the balance of that week will be working in a significantly different landscape. One of the other things to also recognize is that under WTO rules, there are no tariffs imposed normally on financial services. Instead, there are what we call soft tariffs or soft barriers, and they basically are the implementation of local rules that either confer local competitive advantage or seek to neutralize overseas competitive advantage and create something of a more level playing field. So in effect, we'll be going into a system where those soft barriers to trade will actually become more significant. And that, again, is something that didn't really exist under the single financial services market to anywhere near the degree it does outside of the single financial services market. So quite an important new era that we're going into. I did say earlier I would explain what equivalence meant. Equivalence broadly is a concept of mutual recognition of equivalent legal and regulatory standards in financial services and on a case-by-case or directive-by-directive basis. Equivalence was and is designed really to cater for those macroeconomic areas of regulation, such as capital markets infrastructure, payment systems, clearing, settlement, and so on, where in large-scale capital markets, there's a need to ensure continuity of commerce, confidence, and what we might broadly call the avoidance of regulatory arbitrage. Now, one of the important things to understand about equivalence is that there are some EU directives that have equivalence written into them. In other words, there is the ability to recognize equivalent legal or regulatory standards in an overseas jurisdiction, but there are quite a number of directives where there is no provision for equivalence under the scope of that directive. In other words, it doesn't matter how much we might wish for equivalence, it legally cannot be granted. And that's an important factor, which I'll come back to shortly. As far as market infrastructure is concerned, there are a significant number of areas where the EU has already provided equivalence recognition, not the least of which would be with markets in overseas jurisdictions such as the USA, Japan, Australia, Hong Kong, Singapore, etc., where there's a recognition that it's a trading venue, there are settlement systems, there are payment systems that work broadly along similar lines or equivalent lines to those within the EU, and where the legal and regulatory framework and standards in those jurisdictions are recognized by the EU as delivering equivalent outcomes, or in some cases are written locally in such a way that they are virtual mirror copies of what exists within the European Union. And examples of where that has happened have been in some of the Middle Eastern jurisdictions, you know, the likes of the United Arab Emirates, Qatar, to a degree Bahrain, and so on. And these are the jurisdictions that can relatively freely now do business with European Union states and territories. Probably what the most important example in Europe is Switzerland, which is neither a member of the European Union nor the European Economic Area, but nevertheless has very broad equivalence recognition for many areas, or particularly in the services and financial services sector, between its domestic legislation and that of the European Union. And indeed, it's only a matter of a little over 12 months or so ago where there was a proposition within Switzerland to change some domestic law and limit the ability, particularly in the area of the free movement of labour, at which point the European Union reminded Switzerland that that would be a breach of its treaty obligations and promptly suspended the equivalence, particularly in market trading. Needless to say, it took Switzerland very little time at all to actually retract the proposals and to go back to full compliance with its treaty obligations and the restoration of the equivalence regime. So the market infrastructure and the wholesale capital markets and payment systems side is already reasonably well catered for, even though a deal needs to be done on a sector by sector, directive by directive basis. And the FCA currently has completed, I understand, the first tranche of its work on that, so that it can now get down to meaningful discussions, having provided evidence to the EU of where exactly we believe in the UK there is equivalence with EU legislation and regulation on an outcomes basis. The elephant in the room, however, is retail financial services, because in the retail directives, there are no provisions for equivalence in the directives or the regulations. In simple terms, in any areas of financial services that involve the supply of services to retail customers, retail clients, there's no provision for the European Union and the UK to be able to agree equivalence. That doesn't mean necessarily that some form of agreement couldn't be reached, but it's much more likely, again, it would have to be approached on a sector by sector, service by service basis, and would have to be reached by way of either bilateral treaties between the UK and the EU, or by some other form of international agreement between the UK and the EU. Needless to say, those kinds of agreements are not negotiated normally in the span of a few months. Those kinds of agreements normally take several years to negotiate properly, because particularly from the EU standpoint, the regulators will require satisfaction that there is absolute broad equivalence of outcome between what the UK would permit and what the EU would require. Normally, the stumbling block is likely to be in these areas the current insistence by the UK government that the European Court of Justice would not have the final say on any points of arbitration. On the other hand, that is a non-negotiable point of law for the European Union in most cases. So that's a significant area at the moment of impasse and a significant area in which the two sides are poles apart as it stands. So if that's the background and the scene setting, what does this then mean for firms at a granular level? Well, first and foremost, right from the get-go, the FCA has been emphasizing the responsibility of all regulated firms under the systems and controls rules to do proper risk assessment across the enterprise, what we call enterprise-wide risk assessment, and not the least of which specifically to focus on the risks arising potentially from Brexit. And those kinds of risks are important to identify, because a firm might well say, well, we don't really do business in continental Europe. So from the perspective of a UK firm, we don't think we've got any significant Brexit problem. However, when you start to drill down into the kinds of risks that can arise, one of the most obvious ones is that the current free market, free movement of labour principles will now cease to operate. And so where we have employees and or contractors that are currently EU or EEA nationals, they will no longer have the automatic right to remain and work within the UK. And indeed, in some cases, they may not wish to, particularly if they have family obligations back in their home state, and or they have family members who are unable to join them if they wish to remain in the UK. So one of the obvious things to look at is, do I have any employees or key contractors who are or who may be EU or EEA nationals, and do I understand what their employment status and their residence status is likely to be on the 1st of January of 2021? Because that's quite a short time scale in which to apply to the Home Office for right to remain and right to work if it's not already been secured. The second area that's often overlooked is the service supply chain. So many firms will have banking, insurance, telecoms, IT, clearing, settlement of trades, maybe travel obligations that may be provided by a supply chain that actually involves firms based in the European Union. And if that is the case, then will the post-Brexit end of the transitional period regime actually permit the uninterrupted supply of service as it was delivered previously? Now, there's no simple answer to this. The only issue is it has to be checked on a case-by-case, firm-by-firm, supply chain by supply chain basis. The impact, and whether it's no impact or quite a severe impact, will basically be different from firm to firm and case to case. But the point is, the FCA will expect that firms have checked this out and don't get caught out by an unexpected event or occurrence that causes them problems, whether it's a serious problem that would impact on liquidity or capital adequacy, or labour or equivalent. There's also a question of clients and customers based within the EU or EEA countries. At the moment, if a firm has either a service or a branch passport, dealing with clients in overseas jurisdictions and vice versa for those firms that passport into the UK on the same basis, there's no difficulty in doing business with and servicing clients cross-border. But again, that will change. The passporting regime will cease at 11:00 p.m. on the 31st of December. So quite literally from that point onwards, if a firm is not covered by some kind of transitional provision or has not secured authorization in another state, then it may not be able to continue to do business with those clients in the same way that it did before. Now, firms may still be able to supply information or provide basic service, statements and similar to those clients, but actually taking new instructions or actually executing new trades or new transactions may be something that then proves illegal unless they've been properly regulated. Similarly with the scope of services, there are a number of services that we may deliver or wish to deliver on a cross-border basis. And what we mean by that is maybe a client engaged in the UK then moves to an overseas jurisdiction and wants to take further advice, execute further transactions or whatever it may be. Firms will then need to take a decision of, well, do we wish to continue to deal with such clients? And if so, how on earth do we do that? The same will be true, of course, for European firms who may be doing business into the UK on a similar basis. I think firms also need to assess and evaluate the degree to which they do or don't need or require passports to do business. Passports cover a significant number of areas, particularly of interaction with retail clients. So whether that's an insurance company that relies on a passport issued under the insurance directive, under the motor directive, under the life assurance directive, under the insurance distribution directive as far as brokers are concerned, and so on. And simply put, there are a significant number of areas where the supply of services to what we would call retail clients, to people who are not firms or counterparties, makes up a quite significant component of the UK financial services sector. In the UK, the FCA has introduced a provision called the Temporary Permissions Regime, the TPR. And what this will do is allow firms that rely on inbound passports issued by European regulators to do business in the UK. Now, if a firm is reliant on an inbound passport, it needs to think carefully about whether it wishes to continue to do business in the UK post-Brexit. And on that basis, if the firm does, it needs to register with the FCA under the temporary permissions regime in order to then be able to apply for full authorization directly to the FCA as what we call a third country or an international firm. Any firm that doesn't register under the temporary permissions regime will find that its passports cease to exist again from the 11 o'clock deadline on the 31st of December. And as a consequence, they will no longer have the legal ability to do business in the UK. If they are registered under and accepted into the temporary permissions regime, they will be allowed to continue to do business under the temporary permission powers up to the point at which either they are authorized by the FCA or decide to withdraw from the temporary permissions regime. The temporary permissions regime itself is expected to operate for about 2 years, so into early 2023 probably, before the firms that are in the pipeline are all allocated what's called a landing slot and are able to submit an application to the FCA. There's then the question, well, does a similar framework exist for outbound passported firms? In other words, those firms in the UK that currently do business in continental Europe. And the answer is that that will have to be dealt with on a case-by-case basis. There are approximately 27 other European regulatory jurisdictions, some of whom have more than one regulator. So depending on the line of business and sector, and depending on the country or countries in which you would want to do business, I'm afraid it's a question of then seeking advice locally in those territories and trying to work out on a country by country, regulator by regulator basis, exactly how they will actually deliver the equivalent of a transitional relief, if there is one. And the clock is ticking, basically. If firms have not already explored that, they need to do so very, very urgently, because those passports will expire at 11 p.m. on the 31st of December this year. Having set the scene, let me just talk for a moment about some of our experiences here at Complyport to date. I think it would be fair to say that a number of larger institutions who were already in the radar and the crosshairs for the FCA and the PRA did begin to apply themselves to the implications of Brexit. But they were mostly firms in the banking and the insurance sector, and they were aware and alive to the obvious considerations around, for example, the issues that would now be called up to question under equivalence. So capital markets infrastructure, clearing, settlement, payment systems, etc. And it would be fair to say that the majority of other firms perhaps might have given Brexit some cursory scrutiny. But in our experience, the vast majority of firms did very little of a practical nature. Within the last couple or 3 months, however, as the penny, I think, has begun to drop somewhat, that the end, to quote that famous phrase, is nigh, a number of firms have now begun to wake up to the fact that there's quite a bit of work to do. So just to give one example, in the fund management sector, sometimes firms have woken up to the fact that they might have a UK fund or they might have investment management in the UK, but they're now scrambling around to try and work out, well, what does that mean going forward? Can we still manage a fund from the UK that's maybe based in an overseas jurisdiction? Or where we're pretty happy that we've got a UK fund, but we normally market that into the Benelux countries or to Spain or Germany or whatever it may be, can we still continue to do that? And these are the kind of questions that we're now beginning to have to get hands dirty in some cases and help clients to understand and to scope out and then work out what needs to be done. Similarly, in the scope of investment management, it's not uncommon over the last number of years for firms to find that not all of their clients are necessarily UK nationals, or even where they may be UK nationals, they may not all be UK residents. And that then poses questions, well, are there any implications in terms of our ability to service those clients? Are there any implications in terms of our ability to engage with clients who might fall into that category going forward? So the marketing for new clients and the engagement of new clients. And similarly, questions then around, well, what of our services might amount to a regulated activity, as opposed to which of our services might amount to activities such as providing factual information or maintaining service that was pre-agreed without the delivery of new regulated activities. Again, quite a complex area to look at and not one where it's easy to give off the cuff answers. Securities trading is another area. In executing deals with markets, the integrity of that service supply chain is not always transparent, and it's not always clear whether different parties or players in the transaction process are actually UK based or maybe based in a European jurisdiction or a combination of both. So to that degree, there is a significant question around what do I need to do to be able to effectively carry on my business, or do I need to change my business model somewhat? Similar issues have arisen in areas like insurance broking. So for example, insurance brokers are now beginning to wake up to the fact that those engaging, for example, with the Lloyd's market can no longer actually get continental European risks underwritten at Lloyd's, and those risks now have to go through the Lloyd's Brussels operation because Lloyd's itself does not have permission to do business in the European Union. So the moral of the tale is that at this point in time, it would be fair to say firms are leaving it late to plan and to act. On the other hand, the Brexit deadline and the expiry of the interim or transitional period at the end of the year is approaching very, very fast. I think the key question for all firms would be, if you have passports or have relied on passports, whether outbound from the UK or inbound to the UK, you really must rapidly decide whether you need to or ought to register under the FCA's basically temporary permissions regime, certainly for those firms with inbound, and if you're an outbound passport holder, whether overseas regulators in the territories you wish to operate in operate something similar to the temporary permissions regime. Incidentally, the FCA temporary permissions register is currently closed. It will reopen on the 30th of September, and that will be the last chance saloon for firms that rely on passports into the UK to actually register and make sure they secure a landing slot for an application for authorization. So I think it would be fair to say that if you've already secured a landing slot as an inbound firm, the question will be, have you started to prepare your FCA application? And the reason for that is that you may not yet have been given a landing slot, but when you receive one, you'll be expected to file your application in quite a short window of time. And if you don't prepare in advance, you may get caught out by not actually filing an acceptable application within the required window, and thus losing the protection of the temporary permissions regime and not being authorized by the FCA and having to go effectively what amounts to the back of the queue for a full rather than expedited application. The similar issues apply where with a UK firm applying to do business in an EU country, with the added complication that in many cases, whilst many European regulators are happy to communicate with UK firms in English, in some of those territories, the official language is not English. And it may well be the case that the application has to be translated into the official language of the country in order for it to be legally processed. That can not only add to expense, but it can also add significantly to the time required for preparation and potentially cause delay. Again, broadly, the application process itself in most jurisdictions typically takes somewhere in the region of 6 to 9 months. So the assumption that regulators will be able to process large batches of regulatory applications in a short period of time, must be disabused. Sufficient time must be allowed, because if that isn't factored in, then firms will be caught out. One of the other areas that's also important is whether within the firm, within the team, the people concerned have the relevant knowledge, skills, and experience to understand the processes, to be able to deliver the workload required, and to be able to do so to the standard required. And the question would be, if not, trying to recruit or bring in at short notice new employees to do so is a high risk strategy in our view, simply because there is not a large and deep pool of experience with the requisite knowledge. So if you have gaps in your team, then get help fast. And that's, I just apologize for the plug here, but of course that's where consultancy firms like Complyport and 𝗪𝗔𝗥𝗗𝗏 come into the frame, in that we can help. There may also be areas within your company or your team where there are gaps in education, qualifications, basic training, so knowledge and skills, or the required to build on existing knowledge and skills and experience. And again, this is where one needs to think about what training requirements do we have and where can we get the kind of training and development that we need. And again, I would point here to sister companies within our group. The London Governance and Compliance Academy is particularly well suited for those issues that might be more UK focused, and our colleagues in the European Institute of Management and Finance can similarly help with development needs focused more on those European territories outside of the UK. I think it's also important to stress here that whilst there can be a lot to try and take in, 𝗪𝗔𝗥𝗏, Complyport, and other group companies are here to help. We can help with Brexit-related issues. Complyport itself provides advice and guidance and hands-on assistance where required to help firms understand, scope out the issues, and then implement actions required. Complyport and our colleagues in our other sister companies, have specialists in cross-border financial services amounting to many, many decades of experience. We can cover territories and we have experience of markets both within the European Union and outside of the European Union, including the non-EEA European countries, the USA, the Asia Pacific region, the Middle East, and so on. The key thing is we have quite wide market bandwidth, so we can deal with many, many different types of firms, from wholesale firms and capital markets issues across to what we might call firms dealing with retail clients in areas of lending, of insurance broking, wealth management, broker dealing, and so on. And quite a wide range of sectors within the services space that we deal with. That enables us to provide both that market bandwidth that's very wide and the deep dive expertise and experience. Now, I would say I'm very happy to take some questions here. But should you have any questions later that occur and you want some help with, or should you have any queries, I have there the contact details for Complyport and our colleagues in 𝗪𝗔𝗐𝗍.
Paul,
John, I'll hand back to you.
Yeah, Paul, so I've got a very quick initial query. So 1st of January 2021 comes in. My company A hasn't done anything at all to prepare for the hard Brexit scenario. What can Complyport do to kind of assist in a disruption to the business? What is it that you guys can do in Complyport? You know, if you're an investment fund or if you're a broker or you're dealing with financial services, what are the practical things that Complyport consultants can do to keep the business running if they are working with EU-based companies? And in terms of 𝗪𝗔𝗐𝗍, practically, what are we doing? You know, has there been examples already of companies using 𝗪𝗔𝗐𝗍 to kind of put together some online courses or CPD that can help you know, key SLT members or members of staff within businesses to prepare for what could be one of the biggest disruptions to the British economy in decades?
Yeah, well, let me take that question in two parts, and let me split the first part into two, if I may. The answer to your actual question is, if the 1st of January has come and the firm hasn't done anything at that point, to a degree, it's too late and the damage is inflicted. And at that point, we're really into damage limitation. Now, we can work very closely with the firm then to try and put together an application to the regulator, or if it's more than one, regulators that the firm needs to contact if it hasn't already done so, and gain authorization where it needs to gain authorization. So if that was an overseas firm wanting to do business in the UK, then we'd be addressing our concerns towards the FCA. On the other hand, if it was a UK firm that needed to do business in an overseas territory, then we'd be talking to the regulator, or in some cases more than one regulator in those overseas territories within the EU or the EEA, that the firm would need authorization from, or at least if those regulators had a different transitional regime, you know, possibly seeking to take advantage of that. However, what I will say is that the guidance we've had so far, Europe-wide, as far as the EU and the EEA is concerned, is that all bets are off at basically 11 o'clock UK time, 11 o'clock PM, 31st of December. So if firms haven't registered or explored what they need to do by that date, it's going to be costly compared to having acted prior to the end of the year. And on a similar basis, prior to the end of the year, again, we can certainly help and assist firms to scope out what needs to be done, to also look at some creative options. So sometimes it's not always a monolithic solution. Sometimes there can be fairly creative and innovative ways in which maybe a firm already has other European business units. It might be able to, let's say, leverage off in terms of providing interim or stopgap solutions. I can't go into very case-specific examples that time prohibits right now, but we are certainly working with one client at the moment on a fairly innovative way of utilizing another sister company that's already regulated within the EU. In other instances, we've looked at helping firms expedite entry into the UK in, again, relatively creative ways, not necessarily by forming a UK subsidiary, but in some instances by looking to come into the UK as a branch of an existing international firm. So there are solutions we can look to, but I'm afraid we have to look at those on a case-by-case, client-by-client basis. The second part of your question, which was in terms of have clients utilized 𝗪𝗔𝗐𝗍, the answer is yes. In a number of instances, I have worked alongside 𝗪𝗔𝗐𝗍 colleagues in creating bespoke training that's helped them to provide knowledge and skills required to suit specific markets, whether that's a specific national market or whether it's applying Europe-wide requirements that the firm needs to make sure are embedded and are at the right standard.
Yeah. There's a question that's just come in now. You know, previously the Brexit camp was always speaking about the bonfire of red tape. So, you know, by leaving the European Union, we would have less red tape and regulations. Do you think that post-January 2021, we will be a less regulated economy, and especially financial services? Does that mean that there'll be less compliance with whatever the new regimes will come in? Can you see the possibility of the UK economy and the financial services sector, which is key to the GDP of this country, becoming less regulated and having less red tape? Well, what's your opinion?
Well, I'm without wishing to take a cheap shot, but if I listen to some of the 6 o'clock news, 10 o'clock news headlines, one would get that impression. If I actually look at what ministers and regulators are saying in the small print, the answer is that we are expecting regulatory standards to remain the same in the UK. So there will be no slackening of regulatory standard, and therefore I can't see that there's any room to reduce the red tape. What I do foresee is that if the UK has its own financial services system, which closely models but deviates in some ways from the European model, actually many firms will have to have an eye to 2 systems. And to me, that means 2 lots of red tape, not just 1.
Yeah.
Because if we're going to have even cross-border supply chains, then on supply chain due diligence, we're going to have to look at whether the suppliers are actually compliant with their domestic obligations in their home state. But equally, we're going to have to comply with any additional requirements in the UK. And the UK has had a long history of what we call gold plating or gilding European regulation. So if anything, I don't see scope for the UK to particularly break with the habit of a lifetime and start to pare back when the UK was largely responsible for introducing more complex rules than in many other parts of Europe in the first place.
Yeah, there's another question that's coming now. The City of London and the financial services industry in the UK has been the centre of financial services across the EU, and the question is, on the 1st of January 2021, do you still think London will be the top place for financial services companies to base their operations, or are they going to be looking for sort of alternatives? And which markets do you think will benefit from this exodus, if it actually exists, if it happens, from London?
I think in short order, I'm not sure there will be a dam burst style exodus. I think, if anything, there may be a measured drain away. But I think that will also depend. I was at a meeting with the FCA only on Friday afternoon, and they were very clear that they will be doing all that they can to preserve a regime that post-Brexit, so from the 1st of January 2021, will look as close as possible identical to that which exists right now. So they are factoring in effectively a not very significantly changed regime at all. Some of the commentary coming from the government, from Downing Street and from the upper echelons of the Treasury would suggest that the UK might begin to deviate somewhat from the European norm. However, the City Minister, John Glenn, has actually indicated in the small print the opposite. So he's suggested that the scope of deviation might be much more cosmetic than substantial. And that makes sense, because if there is any massive deviation, then bearing in mind that any equivalence decisions or any other bilateral treaty or agreements that are reached with the EU will be called into question. And the EU has a long history of playing hardball on such matters, and has the scope to cancel those kind of arrangements at virtually no notice. So I really don't see the scope there. From the view we have at Complyport and LGCA, we really don't envisage that there would be a dam burst. But if the UK does start to deviate, and if political decisions make the UK a relatively unfriendly place to do business from a European perspective, then I think other jurisdictions, Ireland, perhaps Cyprus, Malta, which are the 3 English-speaking EU members, and maybe other jurisdictions, particularly for funds, for example, Luxembourg, and from the point of view of banking and insurance, France and Germany, may well become desirable destinations. Some regulators, such as the Dutch regulator, have already made fairly significant pitches, along with the Irish regulator, to be a place to welcome serious players who need an alternative jurisdiction to the UK. So we can't be complacent. There are other territories that are very capable of providing a regulatory alternative to the UK. But I think we're going to go into a period of kind of, feeling our way through as an industry and see whether there is a seismic shift into next year, or whether it's more gradual. And if it's more gradual, it may be that the impact is less severe. If there is any seismic shift, then I think the repercussions will be very difficult to forecast accurately, other than it's likely to be damaging for the UK.
Paul, as a final question to some of the firms who are on this webinar today, what advice would you give to them in terms of comms to their clients and stakeholders in the next few months, which have been, described as critical for, finding, some kind of regime post-Brexit? What's the...
Well, I think the first one, I think, John, is consistency. The FCA is already writing to firms on a selected survey basis, asking for quite granular updates in terms of where are you on Brexit planning, what are you looking at, what are you thinking, etc., etc. What risks particularly have you identified? Now, out of that kind of work that firms must do for the FCA, it makes sense for them then to think about their other stakeholders. So the obvious stakeholders being clients. If clients have not already started asking what Brexit contingency plans are, they're very likely to do so, especially any clients that are based overseas. So if it's a UK firm with overseas clients, or if it's a European firm with UK clients, I'd be very surprised if clients haven't already started, and if they haven't already, if you like, are likely to do so imminently, inquiring, well, where do I stand? Because the end of the year is less than half a year away. What are you telling me? How are you going to provide services to me? What are the contingency plans going forward? And I think, similarly, the supply chain that firms utilize is also likely to have a significant interest in, well, where do we stand going forward? Are you going to ask us how we're resourced? Are you interested in whether we ourselves are going to be Brexit resilient or not? I know certainly we at Complyport, and I'm sure colleagues in LGCA have done exactly the same, are already beginning, and we have already assessed what our enterprise-wide risks are, and the fact that we believe we are Brexit resilient. We are able to service clients at home and overseas, and our supply chain is intact and will function, on the 1st of January next year. But if firms haven't done that, then they're likely to get a very rude awakening.
Paul, as a closing statement, can you provide like a horizon planning view for all of our guests to see what's, in the next 2 to 3 months that you're aware of, what's coming up in terms of Brexit and financial services that people should really be aware of, and what should they do to, I mean, I know you've given out the a contact email for Complyport and 𝗪𝗔𝗥𝗗, but what should concerned firms do as a first step? You know, what should they do to reach out to us and, you know, to get in touch as a closing statement?
Well,
and then
the first thing for in any situation like this is just to look at what is the impact on the firm, what risks do we potentially face, and how do we cap off those risks. There's only really 4 broad ways you can deal with a risk: accept it, don't do that kind of business, or try and lay it off to somebody else. And if you can't do any of those 3 things, then try and manage it. And that's the point where you have to have an effective control to lessen the impact of the risk. It takes detailed experience, knowledge, and understanding sometimes to be able to identify what the risks are that you potentially face, but also what to do about it. And that's broadly where the likes of I and my colleagues at Complyport, you know, come into the frame. And in terms of the providing the skills and the knowledge, where colleagues at 𝗪𝗔𝗥𝗗 and the IMF come into the frame. So this might sound a little bit simplistic. It's not meant to be, because it masks a multitude of complex tasks and decisions that need to be made. But it's that first step. It's almost like saying, you know, to be able to swim, you've actually got to get into the water, because everything else is just a rehearsal. You don't actually start to swim unless you've got contact with the water. And that's the case here. The other factor I would add is that this is now very, very urgent. 5 months is a blink of an eye in the kind of time frame and with the kinds of issues that we need to deal with. So if firms haven't already started, they must, absolutely must do so immediately, because every week's delay potentially puts their business at risk.
Paul, thank you very much for that. And to our guests watching across the globe, this is 𝗪𝗂𝗶𝗵𝗏, and if you do want to get in touch, the contact details are online now. It's info@complyport.co.uk or info@𝗪𝗔𝗥𝗗.uk. That was a joint webinar with Complyport and 𝗪𝗔𝗥𝗗, looking at the hard Brexit and what could be happening on the 1st of January 2021. Thank you all for attending today's webinar.